Sir Ivor Jennings framed it best when he said that conventions are the flesh that clothes the bones of law. The rich and historic tradition of conventions dates back to the Norman conquest of 1066 and could be considered a hallmark of the hybrid monarchical republican rule that exists in the UK. Having said that, it is important to recognize the fact that conventions are not legal, and therefore a failure to adhere to them would not attract sanctions or penalties. In such a backdrop, how significant are conventions, and are they important to the functioning of the UK? Perhaps the best example of a convention at work is in relation to the appointment of the Prime Minister of the UK. By royal prerogative, the appointment of the Prime Minister is vested with the Crown. Interestingly, however, the prerogative does not articulate the particulars of whom the Crown appoints. As a result, the King may, for instance, appoint his son as the Prime Minister, if he so chooses, and this would be considered perfectly legal. However, an elected person must become Prime Minister to maintain democracy. Therefore, perennially, the King appoints the leader of the party that secured the most votes at the general election as the Prime Minister by convention. It is therefore interesting to speculate what would happen if the King opts not to.